Joining us now, MSNBC's Fallon Gallagher and Mary Bonato, the Senior Director of Civil Rights and Legal Strategies at Blatt Law. She is also one of the attorneys who argued before the Supreme Court in the Obergefell case. So, Fallon, walk us through what the justices are doing today, what we might expect.
Yeah, Chris, so the justices are having one of their regularly scheduled conference meetings. This is a closed-door meeting that's literally just the justices. It's not open to the public, press, or even staff. It's just them. And they'll meet and they'll discuss cases that are active, so like that tariffs case that we talked about earlier this week. But they'll also review petitions of cases that they might take up. So Kim Davis's appeal is one of many petitions that they're currently considering in this closed-door conference session. Now, the justices will usually consider cases more than once before they decide whether they're going to grant or deny cert, is what we call it. But they could let us know as early as Monday when they release an orders list whether or not they're going to take up this case. And that might come on a very long list of other cases with no background information or additional reasoning. It just might fall under a category of denied or granted. Now, the justices, 4 of them have to decide whether they're going to take up this case, and we could hear as soon as Monday. Chris?
Thank you for that. Obviously, Mary, there is anxiety, not just within the LGBTQ plus community, but I think for people who support gay rights. Is marriage equality in jeopardy?
I hope not. And, bear in mind that for them to take this case, it does take 4 votes. And one of the first things they look at is this case really teeing up the issues cleanly? And as the briefing showed, there's a lot of issues with this one, including the fact that when Clerk Davis first filed her case way back when, she said, I'm not seeking to overturn Obergefell. And she said the same thing to the Supreme Court in another journey to the court in 2019, among many other things. So in some of her questions that she's now advancing are questions that she didn't even raise until her 3rd appearance at the Sixth Circuit Court of Appeals in a reply brief. So really a lot of those issues have not been ventilated. And then even apart from just whether the issue is teed up cleanly or not, there's real questions about why would the Supreme Court even do this? This is something that is working well across the country. Essentially what Obergefell did is say more people can marry and take on the protections of marriage, the responsibilities of marriage. It's good for the kids, it's good for their families, and helps them live their lives and be more stable. So it's hard to imagine. And I guess one other thing I would just note is that a number of the justices have spoken recently a little bit about marriage. They obviously can't talk about this particular petition, but Justice Barrett, for example, in an interview with the New York Times, talked about the concrete reliance interests in a marriage around medical issues and around children. And that's very important because it's one thing, about whether or not this court would have decided Obergefell the same way or not. There's certainly reasons to wonder if they would have. On the other hand, now we're talking about would you overturn it? And it takes significant justification. But at this point, there are so many reliance interests on marriage of kids and families, but also, honestly, employers, businesses, the overall economy and our society has always counted on marriage as something that, really grounds us.
So when some people hear that argument, they remind folks of Roe v. Wade, and they say, like Obergefell, it was law. They thought it was settled. And in fact, they thought it was working well, just as you said, about gay marriage. Are they overstating perhaps the similarities between those two?
Listen, it was shocking to people to have what appeared to be a settled precedent overturned. And it's not the only precedents that have been rewritten or undone. So there's reason to be concerned. I would just say, just to zero in on a legal issue, that in the Dobbs case, the one legal issue that the court focused on was this a protected liberty? And they said, no, there hasn't been like this abortion right since our country was founded or the time of Reconstruction when we passed the 14th Amendment. I would say marriage is different in that regard. But I think the real issue I wanted to note is that for various reasons, the court walled off any discussion of equal protection in the Dobbs case. That's not true in Obergefell. In Obergefell, building on precedents, the court said, yes, there is a right to marry, and it's been announced again and again. And then it also said there's also an equal right to marry. And it said it first in Loving versus Virginia, striking down interracial marriage bans, and it said it clearly in Obergefell. And at this point, when you think about the enormous protections that state and federal governments, private industry and so on accord to married people and how they use marital status to parcel out both protections and responsibilities, it's kind of hard to be equal without knowing that you have access to marriage and to protect your family that way.
Mary Buonato, as we wait to see what the Supreme Court does, thanks so much for coming on the program.